Peace, 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 peace to the gods. Peace to the gods. And this is your boy Rico Blakeney, your host here on In the Circle Ministries. And this is our virtual YouTube ministry here. Give me a second. I'm just trying to get everything situated here on my end here. So you guys just bear with me. Please and thank you. Okay. I was trying to get it over here where I can see and still see everything over here in my comment section and everything else. But anyway, I can see them there. As I was saying before, thank you and welcome to coming out to another broadcast of In the Circle Ministry. And I'm your host, Rico Blakeney. This is our virtual YouTube ministry. We usually do our What's Up Wednesday shows on Wednesdays. Had a little complication with the software, and I'm up and running now. So here we are now. Um, Um, just want to let you know I'm proud of you, continuously working on your self mastery and you growing with inside of yourself and understanding that inside of yourself is where all the great and real work can be done so that you can understand more and more about the God that you are and you can operate in the proper manner as the God that you are to bring the things into fruition for the perfect plan that you have already planned for your life to bring you to an expected end and not an end to harm you. So we do that by doing it through self mastery and taking things and put them up under a microscope. We make our plural eye single. Scripture in the Bible says that if our eye be single, then our body be full of light. And so with that concept, we take things, we put them up under a microscope and see things for in the truth for what they are. Meaning that we can take them within ourselves and see them um, from our spiritual insight and our spiritual analysis, and we evaluate the things through that spiritual lens. The Bible also call it trying the spirit by the spirit, lining those things up that way with the truths, um, whether they're your truth, your belief, and your perspectives, and the truth. You want to line all those other three up with the truth, so as you become the truth, the way, and the light, and the path of the life that you are living into get you down the path that you're walking to be the light or the lamp into the path that you're traveling through this life. So, um, check out our description section too. We have the In the Circle Ministry there, where we also offer our In the Circle University in our educational department. If you click on the links in there, you will see some of the things we promote. Some of the things we offer and we teach there through membership and donations. Um, we have processes of status corrections, um, going through your passport process and having things handled through that through your status correction, and also um, setting um, other things up like trust and operating through trust and through LLCs, learning different ways and procedures or processes to operate in the public and still remain in your private capacity and not losing in your God-given sovereign rights and not have to forfeit them over. Um, or give it to them through volunteer nights as you have already been doing it. If there's nothing you're aware of or it's something that you're just now hearing, those classes and courses and informations and meetings that we offer there would be great for you. So go check those out as well. And for those that go check it out and leave their email, um, we're giving out the free book, Myth Lies about the Straw Man. So check that out. See the thing we got going on in there, and some of the things we're teaching tonight caters around to that same part of the civic in our university department of dealing with statuses and understanding um, your sovereignty and what it is. And this, like the videos I did the other week about the sovereign citizens and sovereign Americans, not the ones the feds have deemed to be a problem. We talked and discussed about those things as well in there. But and the short that I was saying about the vice president talking about in the next 10 years of letting all American citizens know that they are sovereign citizens, and that with their sovereignty, that no one or no corporation or no government can take what's theirs. So saying that in a way is understanding and how to go about doing that process. And as we talk about in the videos too, that there is a system that is out here, and this system that works, that we call the government, whatever. There are ways of operating within it, um, but there's a proper way and a wrong way, and the right way and the easy way is to do it the proper way. Do it the channels that they have. Don't go through a lot of these promotions and people selling you stuff and teaching you stuff, or having things that sound good to you, but actually having no real life applicable remedy in it, and you end up finding yourself deeper in trouble than you were, than your initial situation that you might have been facing, if it were from foreclosures, tickets, or some people trying to get out of federal and civil situations or whatever, missing through some quick online process, accepting for values, and all these other things. There's a right and a wrong way, and those ways usually end you up in a worse situation than you started off with. But check us out, see what we have to offer. Check out a lot of other videos we have on YouTube on certain subjects and topics. That'll be on you to do your homework. But yeah, check those things out too, and also check out the How to Win in Court with Dr. Graves. That'll be a key part too about what we're discussing and talking about tonight. You can learn how to properly defend yourself, how to do your pleadings, how to make your complaints, or to do whatever you need to do inside the court, and learn their rules and their procedures and how to handle all the things you need to inside of there, from drawing up your affidavits, your examples, your exhibits, like I said, your pleading, your captions, and a bunch more other things. That learning how to move the court through way of motions, and different forms of that. Understanding case law and reading court decisions and other stuff that will help you understand what's going on, so you can follow along, maybe with a court decision, and understand what was being said. But to actually see some of those files on certain court cases, you'll need a case. I forgot what they called it. Pacer or something like that, Pacer account, where you can go and actually look at court cases if you know the court number or the case number, docket number, stuff like that. But it's a self-taught pace. I have a UR code or number that goes with it, and the more people that use it, I get a percentage out of it as part of the paid promotion as well. But check that out for yourself. Learn and study this stuff for yourself. Because just like this lady here, you may have to go somewhere and do your complaint and have to stand on your ground and to have things done. And we also have the In the Circle LLC home repair and auto mechanic service, servicing the Lancaster to Columbia area in South Carolina, and the Lancaster to Charlotte area in the North Carolina areas. So any home repair, auto mechanic repair that you need, mobile auto mechanic, or any home repair or renovation that you have, projects you thinking about wanting to do, let us know about them, and we can accommodate you about any way that you need done, from outside, inside the home, under the home, in the walls and new walls. And we also have the Discipleship Ministry Cash App, where if you want to give to the ministry to help us get more software like we have now, and other things to help bring a better experience while we're on here. I would say a better experience for technology, so I can do more, show more. So you have the option and a way to do that as well. All the donations will be given into the ministry for the channel here, and all the things that goes into the educational department will go into the ministry for the upkeep and the upkeep of the ministry and its charitable obligation to the public. But not going to worry you too long, but check out the description section, as I said before, and check that out for yourself. But we're going to jump into tonight's lesson, Victory for the Sovereign. And I believe this is where I was at. So you guys have to excuse me while I get all of this right and choose right here. This is the court case we'll be reading about, and the Victory for the Sovereign. We're reading over Miss Abigail Michael Jordan's court case, her being the plaintiff, or her having her complaint made. So this is what I'm talking about with the Dr. Graves, knowing the difference between if you got to do a complaint or you have to answer a complaint or whatever. But it's Marco Rubio, and he's the Secretary of State. And so we're going to read over this case, and we're going to see some things in here. I'm going to show you and point out a few things, and outside of that, a couple of things from the DS-11 and a couple more statutes and codes that they have inside of them. But the sovereign part about it is that as we understand that every human has human rights, and they are supposed to be constitutionally protected through articles of confederations or through the Bill of Rights, through the Declaration of Independence, not Declaration of Independence, but all the other things inside of the Constitution. Our sovereignty comes from God. God being the one sovereign, and you being a child or being made in the likeness and the image of God, and you know that you are God, then you are sovereign too. And that sovereignty power was invested as the collective, individually, collectively through the peoples of the states whenever the colonies were formed, and well before then, but just for today's purposes, when the colonies were formed, they had um they had God given right, and they seen things as God given rights, as the pursuit of happiness, life, liberty, and the pursuit of happiness to be protected in your own persons and all these other things, and the right for you to be, to say, do, feel how you need to, whatever. You know what I mean? So that's coming down through the Constitution, and you'll see some of those sovereign God given protected rights. But the individual collective people, um, we came up with the government, later on known the federal government or the U.S. government, and they gave their sovereignty and selecting people to represent them inside of their state. And that sovereignty was invested over to the congressmen and everything else into the government. And so that sovereignty that they have is a sovereignty that it hasn't been taken from the people, but it's still in the individuality. You just have to know how to express your sovereignty. And from anything and everything else, I don't care what you find out here online or whatever else, the only way to do that, even in your status corrections, isn't doing it so much through solely through citizenships or delineating your status through status correction, but is your essence of who you are. Same thing we talked about earlier before in these videos when I started first getting on YouTube. Your spirituality is going to be your determining factor for everything. So recognizing and understanding that allows you to see the sovereignty that you have and how you can operate within your delegated sovereignty, or those that you've delegated your sovereignty with, and the way that they created a system and have a system for you to operate freely through it. So understanding your sovereignty is something that she was able to do and get a victory in, and standing in her sovereignty as being God, standing on her religious beliefs. But there's a lot of other things I want to show you throughout this case, where some of it's going to be just my opinion. It's going to be a very strong opinion based on several views, factors, and facts in my head. And so I may not bring all of those points out, but show you enough or bring out enough to whereas it will help you understand or make sense, or maybe get you to seeing things in a different way, or maybe opening your eyes to something brand new that you've been looking at and never seen, or never recognized it in this way. But it's a pretty long read, so um, if you know about and the name of it too was understanding how to read court decisions too. So this is the part of the captions. They want to be in the right captions. So this won't be too much of the teaching of the styling of the caption um, and all that stuff for tonight's lesson. It'll be more so of reading and understanding the language and the verbiage, what the courts are saying and why they said it, and stuff like that. So, but anyway, you have the caption of the place where the court is held at, the caption of the pleading of the individual person and against Marco Rubio. Um, and just for the sake of conversation, if you notice how everyone names is in all cap, most time in civil cases, if these were two individual people, like, and I'm using this loosely, flesh and blood people, a real physical woman and man, then her name would have been written in that proper um, Christian appellation writing of it. It'd been capital A, lowercase Abigail. capital C, the rest of it lowercase, capital J, lowercase. Marco Rubio, same name. It'll be in capital M, lowercase, everything else, capital R. But since these are the two corporations, since he's representing the state or the Secretary of State or the state of Columbia, District of Columbia, not the state, but the District of Columbia, the Secretary of States, and the departments of the Secretary of State who issue out these things. Um, that's why it's in all cap. But if it had been a civil suit her against him in a private civil suit where he could have caused her some physical harm, she sued him in civil court, then styling would have been different. But that's the case number. This is the memorandum of opinion that we're going to read, uh, and we're going to go ahead and get into this because I don't know how long this may take, but here we go. And I will have to come back later on to see if there's anything in the comments. I'll check the comment section later. So when you come in, you can say hi, you can say hello, you can give your thoughts, opinions, or comments on the live, and I'll come back after I'm finished screen sharing and reading the rest of this and check the comments and acknowledge and comment back. Okay, Abigail Jordan has been trying to get her passport since 2019. The problem, a passport application requires either a birth certificate or a letter confirming that an applicant lacks one. And it is Jordan's sincerely held conviction that obtaining either form of documentation would endanger her religious scruples. The the predicament has left Jordan dismayed. She feels called to evangelize worldwide, but does not want to sully her other beliefs to do so. Seeking resolution, she sued the Department of State, the Secretary of State, collectively department, asking the courts to declare she is a U.S. citizen and order the issuance of a passport. So remember that they said this too, because this is what the judges had said in their part and them describing and their interpretation of what was said and done with the paperwork that was filed in the court case. And we'll get to that later. But remember that it says U.S. citizen. And there's something else I want to bring out too. I believe a lot of people and a lot of gurus and other people have been teaching has missed or will not highlight that portion that I'll bring up. Okay, Jordan originally filed pro se, and the circumstances on the ground remaining stagnant. But once the court approved Jordan's request for counsel, now I don't know if she requested it or the courts requested it through her paperwork and other stuff too. So just a prelude before we get into it, I believe that she did file her paperwork with a lot of information that would somewhat be deemed as to a sovereign citizen, while a lot of amendments were made, but she didn't do it in a fashion to whereas her religious beliefs or what she was trying to get point across was saying. And by her not being a citizen but being a national, but that's another topic. But in a nutshell, I believe this is why the alteration, all the amendments to it. Beforehand, there wasn't hearing none. Then neither the courts tried to appoint her one because of the things that normally happen in courts when people are knowledgeable in a sense and kind of know what they're talking about, but aren't able to get it across to the courts where the courts can either really see what you're doing and understand what you're doing, and you're able to articulate that for the courts to move in your favor. Sometimes the video that you'll watch too when people are doing things, they're so out of if they're gonna put your video up on YouTube and call you a sovereign citizen and how you losing in court cases, best believe you fucked up all the way around. Not even with just in the process of going into court and trying that. I'm just saying with your logic, the teachings and the thoughts, and you're scattered all over the place with these things. For if there was a really sincere thing that happened where you can get it in scripted from the way that most people teach you about the citizenship and you not being a U.S. citizen and having the right to still have that passport, the right not have these social security number because you are a national, you're not a state citizen, you're not a United States citizen, you are from the United States of American Republican, or you are indigenous, or you are Moor, or whatever it may be that you're claiming that status from. Um, all of that is what a lot of time I believe that they bring in there, and they may have a good stuff, but she had some stuff that was able to be done in a way it was able to be brought out properly and show some things if you have eyes to see. But like I was saying earlier, there's a lot of people coming here and they're only going to make fun of those that are completely crazy. Even if some of these cases and some of the things that people are saying, they may have 99 things wrong, but one of them could be right in the court still, however, whatever. It's like we talked about the affidavit of Walker Todd, the federal agent that came in and did the thing, and they ruled that out of the courts, and he lost in the higher courts because it said it was against national security, the public interest. It wasn't good for that truth to go out there and for that case to become case law. Because once a court decision and a thing like that, and decision the court makes, it becomes case law, or what a lot of people like to call common law. Common law is just case law. Courts already decided their views, their opinions, their decisions, and the um, um, all of the other legal stuff that they have to back it up, all of the case law and all the other proven information. But anyway, I just wanted to get that out. But let's continue. Jordan originally filed pro se, and the circumstances on the ground remained stagnant. But once the court approved Jordan's request for counsel, the department whistling took on a different tune. What the federal, and listen how they talking junk now. This is what the judge is saying too. If you listen to this language, they're saying that when she was found by herself until she got a lawyer or court-appointed lawyer. I'm not saying this is a twist or something the court's trying to throw out there to you or something. But I'm just saying, a lot of times you've been taught in this place that don't get a lawyer, don't get a public defender, don't get this and this and this and this. But in certain situations, certain cases, you can see where it prevailed and it worked for her. It's just that you need to know what you're doing and how you're able to do it and how that court-appointed lawyer or that counsel is supposed to handle himself. And if they don't, they usually recuse themselves. But the courts give you the right enough people, you get what you need done. Evidence here. But anyway, it's saying that beforehand she was pro se, she was trying to do it on her own, or she was handling it on her own. She had a motion, she had a paperwork, she had all this stuff filed, and it wasn't enough to make the department try to do anything, even with the courts and what she was doing with the courts. That they had their mindset and they were stuck on their answer to their complaint from her about not having a passport. So let's go on. They said that they had a different tune. State and federal officers suddenly cooperated to attain the proper documentation for Jordan in a manner that did not violate her religious beliefs, and the department represented that it stood ready to issue Jordan a passport so long as she filled out yet another passport application and submitted yet another paragraph. Now the department insisted that the case is mute. Not so. Jordan continued to suffer consequences from the department's years long refusal to issue her a passport. So even with that, hats off to whoever the public defender was, or whoever the lawyer was, or the counsel was to help her get her paperwork together, to get it put in a way to whereas the state and the federal people got to what they were saying. Okay, I hear whatever, but here we go. You can get the passport. You don't even need all that. Just fill out this new paperwork, do all this extra stuff, and you can still get it. But we're willing to work with you now that the courts are involved and you've got your stuff in order, and that we know that there's a great chance the courts are going to move in your favor, or we're going to have to show cause anyway. I'm trying to get ahead of myself. I'm sorry. I'm still excited from yesterday. So, um, but anyway, now this is a demonstration that the process was at least document through a process that violated her. Let me start back here. No, so not so. Jordan continues to suffer consequences from the department's year-long refusal to issue a passport. So much is obvious. She still lacks a passport. The court thus delves into the merits of Jordan's claims and finds that she is entitled to summary judgment on them. The courts have said they looked at all her paperwork and everything else. Yes, she deserved to get summary judgment, get everything she asked for. Because she still doesn't have a passport, even with them willing to say that they're able to do it, and she still has been uh, not able to get it. As for Jordan's religious freedom claim, the department imposes a substantial burden on her religious exercise when it demanded she obtain documents through a process that violated her religious belief. So the court says that her religious freedom claim that they did violate it, and the department did impose that grief upon her. But the department has not presented a compelling justification to require Jordan to go through such a process, nor has it demonstrated that the processes was the least restrictive means of achieving its national security interests. So on the court will grant summary judgment on Jordan to Jordan. More Jordan Jordan merits summary judgment on her claim under 8 USC 1503. She has made an unrebuttable prima facie case that she is a national of the United States, not a United States national like you'll see later on in the DS-11 form, and not a national of the United. She was a national of the United States, and that she wasn't a U.S. citizen. Even though the wordplay is different, you understand that a national of the United States, or I mean a United States national and United States citizens is the same thing. But anyway, say that she is a national of the United States entitled to a passport. This adequate remedy moots her claims under the APA and the Mandamus Act, because she did other writs of mandamus, but the Mandamus Act asking for something else, and the APA saying that they violated her in that way as well. But they're saying that the top number one thing that kills all of this other stuff, don't even worry about none of this other stuff, is that her religious freedoms, they was infringed upon, that they did her wrong through that. So that mutes all those other cases too. But they'll get into too why those other ones didn't make it as well. All her life, Abigail Carmichael Jordan, and this is the first section of what went on into the case. This is their decision, what they did, and why they said they gave her the summary judgment. But this right here is going into details. All her life, Abigail Carmichael Jordan has avoided the perceived stain of a social security number. And you see the AMCOMPL. This right here is the amended complaint, the electronic filing, and this is the electronic filing number, and where you can find that at number 24. And this right here is like the citation 3 or part 3 of where she's changed or amended the complaint. And as you go through and see here in different places, you're going to see different numbers, and you're going to see the amended complaint like down here. Let me highlight it like down here with the amended complaint 3220 cited. She did all that in the complaints where all this stuff was added in later on or whatever, but she amended it from the original with the changes. That's what you have to do in the course as well. But we're back up here. Her devout Christian faith teaches her that her God-given identity is sacred, and that the allegiance she owes to her government as a citizen of the United States must be subordinate to her allegiance to her Creator. So that's another part to understand too when we talk about a citizenship, national of the United States, or a citizen of the United States. I'm gonna go ahead and give the spoiler alert. When you read more about the 14th Amendment and the things that took place with that, is that the states lost their right to deem who were citizens. At that moment, you become a federal citizen. You become a strawman citizen at that moment. At the same time, you become a citizen or a resident of that state that you're in. But all of them and both of those are the strawman. They're all still statuses that's connected to citizenship as a United States citizen. So when you get down into the classification and the different names and the different sayings, like a U.S. citizen, a national of the United States, but a citizen, but a non-citizen national, and things of that status, alien. When you think about status in those formats, they're just different statuses are different names for, I'm going to call them like locations, or not location, but they're like different avenues that you travel on. And in this avenue that you're traveling through, or this, wait a minute, let me change that. It's automobile. So this automobile, the way you travel through the world of commerce, or you travel through the government, the way that you are viewed in the automobile that you are viewed is how you're going to be treated. There are certain benefits, privileges, and restrictions on the U.S. citizens. There's a little alteration and the benefit, privilege, and the restrictions on a non-citizen national, or a non-resident alien, or alien, or a non-citizen national, or a state citizen, or a non-national, or a national. But they're all going to be deemed up under the same category, the 14th Amendment citizen. And so that's something else. Hey, you want to challenge me on it? Leave me a challenge. But I'm telling you, I can show you where it's at, and you can look it up and do enough deep. It ain't got to be a bunch of deep research. You have to get out of your bias, your confirmational bias, and understand that a lot of times we've been taught about these different statuses and correcting the status and doing things, which it is correct, but what you and why you think you're doing it ain't. So, but anyway, that citizenship along with that, what gives you your constitutional protected rights. And so this is a lot of things a lot of people don't teach neither, that in order to have the constitutional protected rights, you must be seen in some way, shape, form, or fashion a citizen of the United States. The aliens get their protections as doing that, but if they're here long enough, they can be considered a non-resident alien or whatever. The foreigner, the national, all of them. As long as you're down here and you're working and you're making money, or you're doing whatever you're doing, and you're actually engaged into the public, into society, then those constitutional protected rights come that way. There's a little different in hers than what maybe what most people is, that she was this way from birth, and a lot of people are wanting to rescind, back out, and nullify any other connections with being that citizen. Need therefore enhances the status correction, or the processes of status correction, and people wanting to change those statuses. That's something else we're teaching our group about, how to take that citizenship into your God-given sovereign status, so that you can stand on your freedom, your religious freedoms. But anyway, she done it her whole life, and that's how that went. So I want to tell you that about the 14th Amendment citizen, because she was still said that. Okay, so where were we at? All her life, I'm gonna start back over. Abigail Carmichael has avoided the perceived stain of Social Security number. Her devout Christian faith teaches her that the God-given identity is sacred, that your God-given identity is sacred. You understand that your God-given identity is sacred. The God that is inside of you, the God that carries you, the God energy force that you are, is sacred identity, likeness and image. You're made in that likeness and image. So understand that that is a sacred identity that can't be messed with. And that allegiance she owes to the government as a citizen of the United States must be subordinate to her allegiance to the Creator. So it's the same thing too. It goes with, you can't be an active minister or pastor over a church and run any governmental office, from Senate to mayor or to whatever else. I don't know about on your local level, but Senator, Congress, and all these other stuff. You might have the name Reverend or Doctor and whatever, but you are not actively a full-time minister, because the Constitution and a bunch more of the writings inside of the legal law says that you already have a life devoted to God, and you have no more room to devote anymore to anyone else. So you can't hold the office. Because if you hold those office, you got to take an oath to uphold the Constitution and to dedicate your stuff and give your whole allegiance to that. So how can you be a citizen of heaven and be a U.S. citizen at the same time? How can you be, you know, so there's ways about it. Even though you claim and they identify her as this, but they looked at her sacred identity that was violated and why she got what she got. But let's continue. And so it says here also the same thing I was saying. If her allegiance she owes to her government as a citizen of the United States must be subordinate to her allegiance to her Creator. So my alliance and my allegiance is to God first. My next alliance is to myself and to the God inside of me. Outside of that is my wife and then my kids, and on down to my grandkids. That is where my alliance and my allegiance is. I am a citizen of the kingdom of heaven. heaven, uh, 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 heaven is my home and earth is my footstool. Um, Birds have nests, the foxes have holes, but the real Son of Man, or the Son of God, and the daughters of God have nowhere to rest their head here at this place. We're just sojourning, we're passing through. But anyway, She thus rejects the possibility of being enumerated or marked by the government, such as by obtaining a social security number, as to do so would be threatening with treating the government as if it were God. Her parents share this belief, and this is all the stuff that was added in to help show the court stuff she might have had messed up. So the lawyer or they figured it out and they got it wrote up and presented in the right way. And they talked about Revelation here, how that's the mark of the beast, and her getting the mark of the beast would be in conflict with her spiritual beliefs straight from the Bible and her upheld religious beliefs. And so that they would be treating the government as God, the same way it is if you're working and using that social and you're considered one of those citizens that's actively involved in acquiring a tax obligation or having a taxable event to happen through working through some kind of medium of exchange in the public, then, excuse me, then you have that mark because they're going to get their money first. The government's going to take their percentage out first before you can even give it to your God or the one that you are supposed to give your tithes to or give your 10% or to wherever your allegiance goes to. They're going to get theirs first. And they're going to tell you when, where, how, and what to do. They're going to govern and dictate and everything else. And your God becomes subordinate. Your spirituality and the God of the great universe becomes subordinate to a man-made government. Enough huff and fuss about that. You can read in between the lines on the rest of that. It says her parents share this belief. So it's either that her parents had done the same things and she got this from her parents, but she's expressed this through her way and through her paperwork and everything else. Her parents share the same beliefs. Indeed, her parents did everything in their power to ensure that she did not receive a birth certificate when she was born, including withholding her first name from hospital officers, for fear that applying for a birth certificate will result in the issuance of a social security number. At the same time, Jordan's faith calls her to make disciples of all nations. To carry out this mission, Jordan has been seeking a passport for 6 years. First, in 2019, Jordan applied for a passport and attended a sworn letter explaining that she lacked a social security number for religious reasons and that she did not have a birth certificate for fear she could be assigned a social security number if she applied for one. And y'all remember this conversation too, so I'm going to go to some other things. I pull up, you can see the evidence. I'll talk about what she can, that's all she had to do, and that's all what's required of her to do. And they still didn't give it to her. All right. To bolster her U.S. citizenship bona fides in the absence of a birth certificate, Jordan attached several records, including a sworn declaration from her father, a certificate of her childhood baptism, and a childhood immunization record, among others. So those couple things there that you can have to get your passport with, you can use those things instead of the social security number or the birth certificate in general. But none of those delineates her U.S. citizenship unless you understood what I was saying about the 14th Amendment, period. So if you're born inside of a state, whether you've got a birth certificate or a social security card or not, any record of your birth, and they can prove that you were born in this state or a state, whether through your Bible, through your birth baptism certificate, or you write your own birth certificate, that then solidifies that you are a U.S. citizen. Right? short blank period. You're still a U.S. citizen. Not by presumption, but that is something they've been able to do and get done through the 14th Amendment. And now the federal citizenship is really supreme over the state, and it's the same way when you deal with a lot of things. State has a little bit of rights and stuff like that, but the feds still have got their sovereign power that was ceded over through the state and through different various ways of statutes and laws and power that was invested to them. So what they do allow the states to record these things for them. They're doing the bookkeeping, and you become a resident of a state and you have already been sold off to the feds. You're already state property. You're already a straw man. That identity is already there. Now, unless you go through the process of getting these information, these forms, will they not formally create that thing, but just having that paperwork in general, Just letting you know that that's what it is. Get it notarized, present it to them. You still can be considered a citizen that deserves those constitutional protected rights. So that's the other side about it as well. But anyway, so that was what went on with her. They never got the birth certificate, but they gave them that paperwork. You're not going to see that she's a U.S. citizen on a baptism certificate. You're not going to see that on an affidavit. I don't think her parents would have wrote the affidavit and said that she was a citizen. That's why I think all the amended complaints and all this other stuff was added in. Because I believe her parents were doing the same thing that we would say now to do, is to not get that paperwork. Don't do that. Don't claim that. Don't get a Social Security. Don't get a birth certificate. You are not a U.S. citizen. And in fact, you're not that 14th Amendment citizen. You are a sovereign being that was born in the lands, on the land, indigenous to that land, from God to there, not into that system. But you can operate from there. But that's a separation her and her parents been doing, fixed up and arranged in the court to whereas it can be made for the public to understand. And for those that don't really understand, they might miss it, but that's what they're saying here from my interpretation. Okay. Um, most relevant, the department, this is not enough for the department. Most relevantly, the department stressed that Jordan failed to supply a statement from the appropriate state register of records certifying that there is no birth record on file for her. And all the other stuff supposed to be in straight. So this is what the courts were talking about. The problem with her in the courts, where they were trying to say it was mute, that we'd give it to her now that she done got right. But beforehand, this is what they were saying and doing. We don't care. That ain't good enough for us. I don't care if that is right and what we got written out there in the rules. But anyway, most recently, the department stressed that Jordan failed to supply a statement, appropriate register of deed. This is the department needed to a so-called letter of no record from Jordan to issue a passport without a birth certificate. A letter of no record is documentary evidence that is necessary to confirm a first-time applicant claim of non-existence. This is what they said. The department said, Secretary of State now. First-time applicant claim on non-existence of a U.S. birth record, which is essential in examining the purported citizenship claim of a first-time applicant. According to the department, the requirement that a passport applicant without a birth certificate obtain a letter of no record is critical in preventing not only identity theft and fraud, but it's essential in the upholding of the integrity of the U.S. passport. They are talking a whole lot of shit about not getting that letter. Like, even with all this paperwork, we need it from our system to say that, so we can protect the integrity of the passport, or the integrity of the process that they're pushing to attain the passport. It isn't the integrity of the passport, it's the integrity of what they're doing and how they're doing and they're accustomed to operating. One of the most common types of passport fraud includes in using fake birth certificates or stolen identities when applying for a passport. The letter of no record is a satisfactory precaution to ensure that someone is who she says she is. Among aiming to comply, Jordan visited Virginia Office of Vital Records to request a letter of no record. But the office informed Jordan that she could not obtain one unless she filled out a form entitled Birth Certificate Information, which asks for her name at birth, date of birth, place of birth, hospital or birth, race, sex, and parents' name. So this is all the information that her parents hid or did not give to them on the birth certificate at the hospital when she was born. And they give her all that on the certificate of live birth, or the informational form, the application for it. When they before it was known as the application, it was just the informational form where you were giving all that pertinent information. And so they're like, she was like, this is just the same damn thing as filling out the birth certificate form and getting that birth certificate. So they were saying she had to get this letter, and so she was going to apply. She went there. She was going to get this letter and to do the letter of never having a record, but they wanted her to fill out this other form in order to fill out the form of the non-record to say that we got all this stuff here and there's no record of this stuff. But anyway. So Jordan refused to fill out the form and did not receive a letter of no record. Her passport application was accordingly denied by the department. She appealed that denial, but never received a response. So this is why I lay mute for so long. She never She had it in court. The court saying do this. They said they were going to do that. She went and did all these other things because this is how the case ended up beginning. From there, from the defendant side or the State Department side, is that this is why the case was mute because they agreed to give it to her. She go do all these other things. She reluctantly, willingly went down there to do all these other things and get this letter of non-record. But then they had this other issue that came up by her filling out this birth certificate information, and so no go. So she appealed that to the department, and was still that case was still open. It hasn't been settled, and she let the courts know of her dealings with them and what went on. Because she was being ignored, and then this when she got the lawyer and or the counselor, and she got her paperwork right more and more and more. Then they was willing. Anyway, my bad. George then brought this suit. She originally proceeded pro se upon George's opinion. She said all this happened before she came into the court, so I apologize, getting ahead of myself. So all this happened before she came into the courts and got the lawyer. Jordan then brought this suit. She originally proceeded pro se upon Jordan motion the court appointed counsel and set a briefing schedule and gave the minute orders of when the time and date of when it happened 18/12/18/2024 and 1/21/2025. Jordan's amended complaint brings 9 counts against the department and several Virginia officers. Broadly, it argues that the department and Virginia defendants infringed her right to religious freedom and violated the Administrative Procedure Act, APA, and it seeks various forms of relief, including a permanent injunction ordering the department to issue a passport to Ms. Jordan or to provide her with an appropriate religious accommodation, a declaration that Ms. Jordan is a U.S. citizen and is entitled to a passport, and a writ of mandamus. So these are the two things I'm talking about earlier, the APA and the writ of mandamus, that they said that the religious trumped both of those. While this suit was pending, Jordan contacted Virginia Office of Vital Records to request a letter of non-record. So I was correct. I apologize. I'm going to recant on what I said. So while this was going on, while it was laying mute, I believe, it just, when she went to do all this other stuff, when they said that they started changing their whistle tune, and then she was going to try to work with them too, and they were like, okay, now we've done this, it should be mute. But later on in here, they'll tell you why it's not mute. Letter of non-record again. The deputy request for a letter of non-record again. So the second time, the deputy director informed Jordan that the office would not issue a letter of non-record because of the officer located a birth certificate on file with the name baby girl Carmichael that tracks an ancestry. This tracked with an ancestry.com search that revealed a similar certification, which the parties learned about during the litigation. They didn't have no idea about it while they was in court searching more stuff. What is unclear is how this particular birth certificate was created. Jordan has her suspicion. When she was born, healthcare providers ignored her parents' pleas to avoid collecting DNA or any information to make her into that U.S. 14th citizen, and to keep her DNA because of certain other reasons we won't talk about on this platform tonight. From Jordan, that could then be transmitted to the SSA, Social Security Administrator, under the enumeration of birth program. The way newborns attain a Social Security number. Here, healthcare providers dishonored that request when they removed Ms. Jordan from her hospital room in the middle of the night and drew blood to record her DNA. These same providers also started the Ms. Jordan could not be taken home until her parents provided her name for birth records. That's another thing they'll do to you too, hold you in there, have you locked up, have your baby taken away from you and separated while they do and get whatever they want and then give your baby back to you, ignoring your God-given rights and your God-given law that you just gave and decreed about that with yours. But you got to understand too, when you go to the hospitals, you're going to another ward, you're going to another place that they have their jurisdiction. So have your stuff set up well before. When you go make that agreement, if you're going to go into the hospital, have your child, have your paperwork set up from the first time that you're going to make that appointment, and have your shit in line to give them about the way you're going to do, how they're going to do, how things will be handled with your care prematurely before going in. Okay? These same provide, okay, and birth record was ultimately relented. Still, this sequence of events likely resulted in the creation of a partial birth record for Jordan, which she never knew existed until now. Meanwhile, the department in Virginia defendants cooperated behind the scenes. In February 2025, they broke major news to Jordan in the court. The Virginia Office of Vital Records decided to forward the letter of non-record to the department, obviating the need for Jordan to fill out uh, any offending forms. Jordan then voluntarily dismissed her claims against the Virginia defendants with prejudice, not voluntary dismissal. At the deadline for Jordan's summary judgment motion loomed, the department informed Jordan that the letter of no record satisfied the documentary requirements for a passport. Department reply. You just read that from the man and the person that did it. So it told Jordan that it could issue her a passport if she submitted a new application, a current photograph. It also agreed to expedite her passport application and assigned her a person of contact to facilitate the process. But Jordan remains unsatisfied. She has refused these offers, arguing that there is no sound reason why she should have to fill out another application to receive her passport, because she has to pay for that as well too. She also fears that this situation could repeat itself upon her inevitable passport renewal in a decade. More, she notes that the department could revoke her passport at any time, require her to submit a new letter. So she sought a judiciary enforcement consent decree from the department, offering to terminate the litigations if the department signed on, but the department rebutted their request. So she was asking the court, saying, look, they probably gonna do some more flim flam stuff. I don't trust it. I don't like it. I'm not doing all the extra stuff, and I shouldn't have to, because I've given them enough and they've infringed on me enough. Just give me my passport. And she wanted them to sign paperwork saying that they were going to do right and do all this other stuff and hold them by that letter of the law, but they refused to sign it. Okay, so Jordan proceeded to move for summary judgment against the department, filing the present motion. The department responds with its own motion to dismiss, or in the alternative cross motion for summary judgment, contending that the case is moot and that it is not moot. They said they will move for cross judgment, and they wanted to shut down because it's been moot from the earlier part of what they already discussed, what we read about earlier, about saying she could get hers. All she got to do is this. So we came to agreement. There's no need of her to worry about that. It's moot. The court held a motion hearing and is now set to rule on it. Rule on the cross motion. If a suit is not a case or controversy, under Article 3, the court lacks jurisdiction to hear it. North Carolina in the court cases. So when a party moves to dismiss for a lack of case of controversy, such as by claiming the dispute is moot, that's what they were saying, that we have no more controversy. She can get her passport. She just need to do all these other things. We're straight. We accommodated her. She don't have to worry about even getting that letter no more, filling out the extra paperwork she don't want to. We got a piece of information now, and that suffices for her. But she got to do all this other stuff, and then she can get it. So that case is moot. And they said that there is no controversy in the case, that there is no argument or there's no dispute to be, or no fact to be disputed upon, that they both agree. So now the courts have no jurisdiction because we settled this. The court can't come in and intervene to unsettle or try to resettle something. Okay. So when a party moves to dismiss for the lack of case of controversy, such as by claiming the dispute is moot, the court evaluates that claim under Federal Rule of Civil Procedure 12b-1. That's another court case and everything else, and citation that goes with it. While the court will accept factual allegations in the complaint as true, those allegations will bear closer scrutiny in resolving in a 12b-1 motion than it resolves a 12b-6 motion for failure to state a claim that relief can be brought upon. That's the rest of that abbreviated part there. And the court may consider materials outside the pleading in deciding whether to grant a motion to dismiss for lack of jurisdiction. While usually it is up to the plaintiff to show that the court has jurisdiction, it is on the defendant to establish that a once live case has turned moot. So the same way The burden of proof is on the plaintiff to prove that the court has a right to bring them in, the defendant into the courts. So it is on the defendant that had been brought into court to say that this has already been settled to show up upon the amount of evidence that this case is moot. That's already been settled and taken care of. So that's something like the same thing they talk about in other processes that you hear about: acceptance for value, doing the administrative process, selling this thing out of court with the three letters: acceptance, letter of acceptance, dishonor, and notice of dishonor, and then notice of dishonor, and then having to settle that way too. So that's another way of doing it inside the courts. But anyway, that's for the private process. They won't use it in the public, in a sense. While usually it is up to the plaintiff to show that the court has jurisdiction, it is the defendant's established that the court case has been turned moot. This is a fundamental burden. A party is entitled to summary judgment if it shows that there is no genuine dispute as to any material facts and that the movement is entitled to judgment as a matter of law. At the summary judgment stage, the court must examine the facts in a record and all reasonable inferences derived therefrom in a light most favorable to the non-moving party. This mode of analysis serves to separate the jury's functions of making credible determinations, weighing the evidence, and drawing litigation inferences from the facts from the district court role as the arbiter of legal questioning. When parties file cross motions for summary judgment, each motion is viewed separately in the light most favorable on the non-moving party, with the court determining for each side whether the Rule 56 standard has been met. And that's another stuff you'll learn about Rule 56 and some more other things as well. The more you get into the Dr. Gray thing I told you about earlier, learning more about the courts, how they work, learning the rules of procedures of the court, federal rules of procedures, and things of that nature as well. So let's continue. I got several more pages. The court begins as it must with just jurisdiction, and it concludes that the department has failed to satisfy its burden of showing muteness. The court thus proceeds to Jordan's substantive claims and conclude that Jordan is entitled to a summary judgment on them. So they couldn't prove it, that it was mute, and the court still ruled on Miss Jordan's behalf. A case turns mute, thus falls outside the use species of Article 3 when the issues prevent are no longer live and the parties lack a legal cognizable interest in the outcome. In other words, the muteness inquires asks whether events subsequent to the filing of the complaint have so transpired that the decision will neither presently affect the parties' right nor have a more than speculative chance of affecting them in the future. A defendant bears the heavy burden of showing that a live controversy has expired. Still, there is a wrinkle in the general rule. If the controversy expiration stems from the defendant's voluntary cessation of alleging illegal conduct, the tribunal is not deprived of power to hear and determine this case. So they're saying that even with that controversy, just because the defendant said, "Hey, I'm sorry, I made it wrong. We can drop this right now. I'm going to pay them, and we'll be straight." The court still has a right to rule and put that summary judgment in place to make sure that it can be enforced. And it's just not just mute because you said that in the courts. It's just okay, it's settled, no more dispute. Everybody go home. Hey, pay the man. Situation get straight out. Y'all go back to business. Thank you. It don't hurt. It don't happen that way. So when a defendant argues a case is mute because it was willingly stopped the challenged conduct, the defendant must make two more showings to prevail. First, it must show that there is no reasonable expectation that all alleged violation will reoccur. Meaning that just because I said I done stopped it, we good, I'm going to pay you, don't mean that I'm going to wait till we get out of court and say, man, I ain't paying you shit. Fuck that. Get it in blood. Whatever action was done is not saying that it won't reoccur again. And second, it must show that the interim relief of events have completely and irrevocably eradicated the effects of the alleged violation. Meaning that whatever you said that you don't do, you don't got rid of it and fix that. So you said, Your Honor, we're straight. I'm sorry I done that. You paid that person right there in the courtroom. Now the case is mute, it's settled, it's done. You've shown that that can't be handled no more, so the case is mute. So if you can't do that to show that you can't reciprocate or you're going to cause that type of harm again later on, then the case is mute. The department has not satisfied this arbitrary burden. To begin with, the court affirms that this case is best understood under the voluntary cessation framework. The department argued to the contrary. I'm gonna read through a lot of this, and this is the stuff you have to deal with because I want to get to the rest before it get too late on me. And I want to show you some other things. And give me 1 second. I'm gonna check and see is there anything in the comment section real quick. Like I said, I did want to keep up with that. So give me 1 second and let me check some things out. Let me pause this. Okay. I don't see nothing there. Okay, so the department has not satisfied that abbrevious burden. To begin with, the court affirmed that this case is best understood under the voluntary exceptions framework. The department argued to the contrary at the motions hearing, contending that it is not the department which voluntarily ceased unlawful conduct, but rather the state office of vital records. That was an issue between plaintiff and Virginia. It wasn't, and that wasn't a situation that could be controlled by the Department of State. The arguing goals has required a letter of no record all along. Now, with the letter in hand, it is prepared to issue Jordan a passport. According to the department, it is the state's office that suspended the requirement that Jordan provide personal identification information in order to attain a letter of no record. But ultimately, giving that letter to the department of its own violation, thus any doctrine that contemplates the department seizing challenged conduct and argument proceeds in inept here. The court sees things differently. Before this lawsuit was filed and counsel was appointed, the department was adamant that Jordan herself supplied the letter. On counsel started clamoring, the department shifted courses, initiating efforts to independently obtain the letter from Virginia's Office of Vital Records. After the filing of the amended complaint and in an effort to resolve this matter, understanding counsel certifies to the court that he worked with the Virginia Department to attain the letter of record. Jordan contemporaneous efforts failed. Her counsel wrote to Virginia officers explaining Jordan's religious objections and requested that the officer conduct a search of his records, and upon confirming that no birth record exists for Mrs. Jordan, provided her with a statement of no record of birth. Jordan's counsel stressed that she would pursue appropriate legal actions if the letter was not provided within a reasonable time. The office responded weeks later by telephone, informing Jordan counsel that it was declined to issue the letter because the office had located a birth certificate with the name baby girl Carmichael, and it stated that it could not provide Mrs. Jordan with documentation of any kind unless she applied to amend the existing partial birth certificate to add her first name to the certificate. So they want her to go ahead and add the rest of the information. Through Jordan's own attempt stalled, the department prevailed. The office forwarded the letter directly to the department, which means shared it with Jordan's and her counsel. I think they sent the letter first to me. Thus, the department suspended a practice which Jordan objected to, the requirement that she obtain and supply a letter of no record. This makes the voluntary cessation doctrine a clean fit, and the department has not met its burden and overcome the voluntary cessation exception of muteness. It starts off well. The department has satisfactorily shown that it is absolutely clear that the alleged wrongful behavior would not reasonably be expected to reoccur. The department counsel has represented that the department will keep the letter of no record in Jordan file so her passport will not be revoked or ineligible for renewable based on the absence of the letter of her birth certificate. The court credited this citation in its settled practice fully to attempt representations such as these when determining whether officers conducted well recur. Relying on government counsel representations in court when assessing voluntary secession exceptions. More, only a first-time passport application must apply either a birth certificate or a letter of non-record. So even if the department were to eliminate the letter from Jordan's file and go back on its word, Jordan still be eligible for a passport renewal. Put differently, there is no basis to conclude that Jordan will ever have to obtain a letter of no record of her birth certificate again. Jordan's argument to the contrary sounds in conjunction. She insists that the department could revoke her passport, and it goes on to talk about that here. Let me finish this. In other words, the department has met its burden. So they're saying, in other words, the department was saying, in other words, the department has met its burden to show that there is no reasonable expectation that the alleged violation will occur. Jordan may not rebut this showing with her speculations. Plaintiff could not overcome government muteness showing where the record contained no evidence that plaintiff's fears of reoccurrence could materialize. The department has met its burden on the first element of the voluntary cessation test, but it falters on the second. Jordan continues to face consequences from the denial of her passport application, while the department represents that it stands ready to issue Jordan a passport. It refuses to do so unless Jordan submits an updated application for a new photograph. This extra hurdles constitutes efforts of an alleged violation. Had the department dispensed with the letter of no record requirement and acknowledged Jordan copies evidence of citizenship of that she could have that passport now, and she would not be forced to exert more time, energy, and money to attain a passport that all agree is rightfully hers. The department may think that these are nothing more than de minimis administrative burdens, argue that this case is not a sound case of counsel's or the court's time. The idea that the department should have to forego other policies does not preclude the case as being mute, but it does not point to any case law that establishes a threshold for when ongoing harms count and when they do not. Further delays the obligation surely suffices. Indeed, in a relevant vein, of Supreme Court has acknowledged that a plaintiff request for normal damages can keep on otherwise mute case alive. So they're saying that just because they said all these other things and she can do her paperwork, she can do all this other stuff, that doesn't mean that this extra burden that you're doing now isn't the same type of retaliation or the reoccurring of the same issue or burden that you put on her in the first place that you said it was mute from. So this is extra burden. So it's the same burden, just extended. Okay. Further delays and obligations surely suffice. Indeed, a relevant vein in Supreme Court. Okay, I read it. This reflects that even seemingly small forms of relief are concrete and effectuate a partial remedy. Thus, the possibility of this insurance can provide redress to a plaintiff. Similarly, in the standing content, courts have roundly recognized that the amount of economic harm is irrelevant to the standard inquiry as a dollar amount of economic harm and still an injury in fact for standing purposes. The department has not shown that the court, why it should depart from these precedents, collectively wisdom, so-called minor harms, which still they'll try to say her has to put her stuff on her, filling out that paperwork and adding her name to her first name to that partial birth record. Her getting the money, getting another application, getting another picture, and doing all the other stuff, that was for minute, that was small things. And the court considered it small. They said that you don't get to decide that. We're still inactivated judicial relief. Keep a suit in the land of cases and of controversy. For just doing that, kept it in controversy, so it can't be mute. Here, Jordan faces ongoing harm. The department is making her extend more labor before she can attain a passport she should have received 6 years ago. Concrete drain on their time, and they got court cases stuff. Plaintiffs concrete drain on their time and resources. This injuries can be avoided if the courts intervenes. Since an aspect of Jordan injuries persisted that can be relieved by an appropriate court order, this case is not moot. This court therefore turned to the merits of Jordan claims. Let me see how many more we got left to read on here. So I'm not going to read all the way down to 29. Y'all have to continue to read on into that, but I want to pull out a few more other things here. I just wanted to show you that. Before we do that, beginning with Jordan's alleged allegation under the Religious Freedom Restoration Act, this status provides that the government shall not substantially burden a person's exercise of religion unless it demonstrates that applications of the burden of the person is in furtherance of a compelling governmental interest, and it is the least restrictive means of furthering what compelling government interest. Even neutral, generally applicable laws are susceptible to a challenge under this law, under the religious thing, that all those laws are subject to that. Whether the department has violated the Religious Freedom Act or whatever, this boils down to two phases. First, the court asks whether the challenge conducted substantially burdens the plaintiff's religious exercise. If so, strict scrutiny applies. And you read on later on in the case, you read it yourself. I probably won't do it for tonight because I want to show you this other information. That you see how the court scrutinized their ass for this too, because they did get caught violating her religious belief. So the sovereignty at the end does get her win. The sovereign does win. God does become victory in the end. So understanding your sovereignty is another reason why I'm talking about everything on this live tonight. And so when you do that, and you come even through us and through the Inner Circle University, we help you understand it, show you that, and how to operate it, and how to adjudicate yourself to make sure that your sovereignty stands. Okay? If so, strict scrutiny for the stage that the courts probe whether the imposition of the burden was in pursuit of a compelling government interest, and inquires whether the pursuit of the interest required imposing the challenge burden, it is a stringent and exceptional demanding test. Only if the answer to both strict scrutiny questions is yes and the determinant justifies is so. So you have to read through the courts and how they viewed it and read through it. Or maybe I'll do another video and show it to you. But let me see if I can get down here to the last part of how the courts, and then let me roll up. This Constitution does, okay, so we're going to read this last part. D, the final note on remedy and order. So what happens when your religious freedoms are imposed up and the court rules in your favor? In a sense, this is what and how the court views and how they're going to deal with when you bring God into the court and Jesus be your lawyer, Jesus be your counselor, Jesus your court, a lawyer in the courtroom, and you bring in and you solidify that and set yourself up that way, the courts will back you. A final note on remedy is in order. The court will provide Jordan with the injunction relief she requests, an order directing the department to ensure Ms. Jordan a U.S. passport forthwith. The traditional scope of injunction relief is that the extent necessary to protect the interests of the parties. An injunction should be limited to the inadequacy that produced the injury, in fact, that the plaintiff has established, and no more burdensome to the defendant than necessary to provide complete relief to the parties. Jordan harm stems from the department's persistent refusal to issue her a passport in violation of her right under the Religious Act. Absent such violation, Jordan will now have her passport in hand without the need to shoulder additional administrative burdens and costs. Thus, an injunction directing the department to issue the passport and this is necessary to remedy Jordan's injuries. Such release is not duly burdensome to the department. The most recent photograph of her and all her stuff, so they said give it to her. The Constitution does not This is the part I want you to see too. The Constitution does not contemplate that judges be spiritual arbiters. If anyone sincerely believes she or he risk her salvation by taking some action, the government may not condition a benefit on her doing so. To find otherwise would be to arrogate an abhorrent authority. You don't have it. Sovereignty is in God, and you being God has the sovereignty. They can't do that. The court would not oblige Jordan to follow an agency assessment of her personal conviction. She is entitled to serve and judgment passport. And so if you read up in here too, you're going to see how the courts and how the courts talked about having your religious belief and how the courts viewed it and all those other things. But so things I want to show you too, some things here, and hopefully I continue to do this. Okay, with the DS11, there was a few things I was looking at earlier. When I talked about the Social Security number, she didn't want to give it. So the birth certificate was one thing. Another thing we talked about, and a lot of things talked about in this movement is not putting the social on the passport. So if you don't have the birth certificate or have that letter of none record to get that social security number, then they're saying you can't have a social neither to apply for it. So I think this was another part of the process that wasn't talked about in the court case, in the sense that not having the birth certificate and not having a social security on the application. Okay, it says a social security number. You must provide a social security number if you have been issued one in accordance with section 6039E of the Internal Revenue Code, 26 USC, 26 USC 6039E and 22 USC 2714AF. And I'm going to pull both of those up and read them up to you. But before we do that, we're going to, finish this little bit of reading here. And if you do not have a social security number, you must enter zeros in the field and submit a statement signed and dated that includes the phrase, outside of I declare by the penalty of perjury, all this stuff is true and correct, and I have never been issued a social security number. Her dad, no, they did this. This is what I believe was in that court paper. They did the affidavit. I don't know if they declared under the penalty of perjury or they did. I affirm that they're affirm that all statements are true and correct, and I've never had applied for a social security number, so she should have been able to put her all zeros. That should have been suffice. The birth certificate, her baptism, and the records of her having a shot should have been enough evidence for her to send in with that and get her passport. So I'm just saying there's a couple things that we've been taught or has been taught about how to do these things on the passport application and how to get it without the social that's ended up you in trouble. They clear cut tell you how to do it here. The explanatory statement is something else that we'll talk about, that we offer and help you understand how to delineate your status and get all the stuff put in the right place. But these are some of the other components that must go with it. So if no one else is telling you this, I'm telling you that now. You're going to fill out all zeros because you've never had a social security number. If your parents never applied for you one, you never had a birth certificate. And so therefore you never have a social security number. So you can get your certificates, you can get your document that tell you here and there instructions on the things that you can do and how to do it. But we're going to look at the 6039E and why does that play important. So this is 26 U.S. Code E information. Notwithstanding any other provision in law, any individuals who apply for this is why I'm reading the whole thing. I'm just not going to go to E, but you need A in order to get to E. Applies for a United States passport or a renewal thereof, or applies to be lawfully accorded the privilege of residing permanently in the United States as an immigrant in accordance with the immigration laws, shall include with any such application statements which include the information described in subsection B. And this is the TIN, the same thing as Social Security number, but this more so is catering to the alien people that want to come over here. Tax identification number. But for a U.S. citizen, your tax identification number is your Social Security number. For the foreigner or the alien or the person that's speaking about up here, the immigrants, they get TINs or ITINs and TINs. In the case of a passport application in a foreign country in which the individual is residing, all the other stuff doesn't matter. But Anyone that's applying for a passport or renewal or thereof, that's what we're sticking for. We're just going to say for the Americans. If you don't have that social security number, so this is the rule that they said that they're going by. If you don't have that social security number, you put in them all zeros, and you send in that affidavit saying that you never applied for one, this is what should happen. The Secretary of State may by regulation exempt any class of individual from the requirements of this section if it determines that applying this section to such individual is not necessary to carry out the purpose of this section. So there's no need for me to put my social security in if I never had one of all those other things. The court case was saying that you trying to say, oh, this is for national security. That is BS and that's uncalled for. You got your affidavit, you got your certificate of birth or whatever that may be, not even the certificate of birth, but your signed document saying your baptism or whatever else. And these letters and the affidavits from your parents saying that they never applied for one and you saying you never applied for one should be good enough. And he should use exempt E. He should use 26 USC code in his decision making when he get that application and give it to you. That means that the secretary may by regulation exempt any class of individual from this requirements. The exempt them meaning this don't apply to you. Don't worry about it. Thank you. Here's your passport. Okay, so let's go to F real quick before I get off of here. So when it comes with the 26 U.S. Code 27014AF, revocation or denial of passport in case of a certain unpaid taxes. That's what this is dealing with. This is what this title deals with. So it's not the social. It's not the birth certificate. But F, revocation or denial of passport in case of individual without a social security account number. Denial. In general, except as provisions under paragraph B, upon receiving an application for a passport from an individual that either does not include a social security number account number issued to that individual or includes an incorrect or invalid social security number willfully, intentionally, neglectedly, or recklessly provided by such individual, the Secretary of State is authorized to deny such application and is authorized to not issue a passport to that individual. And that goes into the emergency thing, the humane thing, but that really does nothing else. So this is what should have been read first. Saying if you think about it from the DS11 form, this should have been first before the exempt part, before the 6039E. This should have been first. And saying that if any person provided under this paragraph for receiving an application for a passport from an individual that either does not include the social security number issued to that individual, includes an incorrect or invalid social security number, where you're putting in all those zeros and you apply for a social, or you go to messing up numbers. If it includes an incorrect or invalid social security number willfully, intentionally, negligently, or recklessly provided by such individual, the Secretary of State is authorized to deny such application and is authorized to not issue a passport to the individual unless 6090E comes into play. When you come back to 6090E, it tells you why you can get that exemption is that if you've applied for that passport, and when you get back to the DS11 form, if you don't have it, man, and you don't have all this documentation they tell you to have here to go with the things in here, then he's going to reject it. You have those documentations about we talked about earlier about just not having that social security number, and we're talking about more how not just rescinding it, but not using it for your religious belief, and how you can explain that and still get it by putting in all zeros. We'll talk about that as well in the private. But if you do those whole things, that's the only reason he can reject it. And because you got one, you don't have that letter, you got a social security card, you have a birth certificate, and your parents applied for one, and you try to put in all zeros, you're not getting one. Some shit they taught before, or that was taught before in the process of getting a passport. But okay, and so those were the things I wanted to show you with that. So when you get into the DS11, they're talking about a social security number, those things here, then it's got a full list of the things that you can accept for your birth certificate. If you don't have it, a hospital birth record, of course you don't have that. The earlier baptism or circumcision certificate. Then either one of them will have nothing no more than the state that it took place in. but it will not have anywhere to mark as you being a U.S. citizen. If anything, it will have your spiritual denomination in your mark, and you've been a Baptist, Southern Baptist, or A.M. Zion. These are the people of place, and this is your spiritual identity. This is your alliance. This is where you will have that at. Okay. Early census, school, medical, or family Bible records, insurance files, and published birth announcements such as newspaper, notarized affidavits, or older blood relatives having knowledge of your birth may be submitted in addition to this affidavit, notarized affidavit. So there you have it. There's ways about going about it, by getting it and having your sovereignty. More detail, like I say, you have to join the group and join the university and become members over there to figure out how to get it done properly and get it done. But there is victory for the sovereign, and there's a proven case for it. Even though her paperwork might have been jacked up and they had to fix it, she had a good enough knowledge and well based to whereas her religious belief is what trumped everything. So there you have it. I want to thank you guys for coming out tonight and joining me tonight. Thank you for your time and your energy. Thank you for investing in yourself. And let me check the comment section again real quick before we get out of here. And what's up, Miss Blakeney? I see you over there. Okay. Well, I'm finished for tonight. Thank you, Miss Blakeney, for joining in. Thank you, honey, for coming in and listening and showing support and love. Thank you for those that will be coming in and watching later on. For those that didn't catch it live tonight, may come back and watch the live stream. If you wait to the end, this is where you're going to get your remedy. So, peace, love, prosperity, and screen web to everyone. I thank you and I love you. Catch us next Wednesday on our What's Up Wednesday show. But for tonight, that will be all for tonight. So I want to thank you once again, and you guys have a great and wonderful night. Now, how do I get here to get the rest of this? I'm at stop sharing.